Hello friends, welcome to you once again on my video, and this time the video is on case diary. That is daily investigation police case diary. Dear friends, when an offense is committed, then police start investigation and the investigating officer prepare a case diary for the purpose of conducting investigation. Whatever he has noticed, wherever he go, to whomsoever he met, to whomsoever he questioned, and whoever give him statement, all is recorded in the case diary. That case diary is not a substantive piece of evidence nor a corroborative piece of evidence. Yet it is very important for some significant point which I am willing to explain to you and to tell all of you, which is very important, my dear friends. When the police officer required the same for the purpose of refreshing his memory according to section 172 subsection 3 of the CRPC at the time of deposing during his cross-examination, then he required the same for refreshing his memory, then he can use those contents for the purpose of deposing before the courts. And at that time the counsel for the defense, that is the accused, become entitled to cross-examine that investigating officer on the aspect of that particular case diary that is limited to that aspect only. He cannot go beyond that. He can put forth, he can contradict, and he can counter him that, okay, this is, you have stated in your examination, but in your case diary you had stated this fact, you had investigated in this manner, you have not, you are stating which is very contradictory to your statement that you are stating in your examination in chief. Therefore the counsel for the accused can contradict and can counter and can confront the police investigating officer at the time of refreshing his memory through that case diary. However, the court's rights, it's not fettered. It is totally unfettered. The courts have, the trial court especially, are within its rights to summon the case diary, to see the case diary, to use the case diary for the purpose of contradicting the police officer. And that is specifically and categorically has been held by the Honorable Supreme Court of India in Balmukund case. What is actually the name of the case? It is Balakram versus State of Uttarakhand in 2017 in Supreme Court. That is categorically held by the Supreme Court that though the accused according to section 172 subsection 3 also is not very much entitled to use that case diary or to confront, to contradict the police officer unless and until the two conditions are satisfied. Either the police officer himself use that diary for the purpose of refreshing his memory while deposing during his cross-examination, or the trial court itself use the extract or use the case diary in entirety to contradict, to counter, to confront the investigating police officer. Dear friends, the case diary cannot be used against any other person except the person, the police officer who has prepared the case diary itself. Further, my dear friends, it is also very important to see what is the benefit of the case diary. My dear friends, in case of P. Chidambaram versus Directorate of Enforcement, the Honorable Supreme Court of India has categorically observed and held that the case diary can be used by the apex court, that is by the High Court or by the Honorable Supreme Court of India, for the purpose of determining whether the trial court or by the High Court, as the case may be, has decided the case in correct manner. Further, to decide whether the case has proceeded, whether investigation has proceeded in right direction, there is no misuse or abuse to the process, there is no misuse the power by the investigating officer, and if there is so, these all issues can help the trial court, the High Court and the Honorable Supreme Court of India to determine whether the case is correct for the purpose of granting regular bail to the accused or for anticipatory bail to the accused. The prosecution generally demands custody of the accused. The prosecution generally demands the judicial custody of the accused, and the case diary would help, would assist the honorable trial courts as well as the apex courts to determine whether the custody should be granted, whether the judicial custody should be enhanced, whether the anticipatory bail or regular bail should be granted or not. So this is very important aspect of criminal law, my dear friends. One more thing I would like to add, and I want to make clarify over this aspect, that the defense counsel cannot use the diary, the case diary, as any piece of evidence for its defense, because according to section 172 subsection 3 it is barred. And if the memory and for refreshing the memory or by the investigating officer, he used that during his deposition, during his cross-examination, or the trial court contradict for the purpose of contradicting that particular investigation uses that case diary, then only for limited purpose under section 161, 165 and 145 of the Indian Evidence Act, the counsel for the accused, or you can say the defense, got the opportunity with limited purposes to cross-examine that individual who has prepared, that police officer who has prepared that investigating diary. Therefore, my dear friend, this is very important for the purpose of the legal practitioners or for the persons who wants to join this profession. And knowledge, my dear friends, is always good for everyone, either he is a legal professional or not, because it is very much categorically held in Indian law that ignorance of knowledge is no excuse. Therefore, for the purpose of acquainting, my videos shall keep coming. Therefore, I would like to say you thanks for watching this video. Thank you, friends.